Jennifer Lopez was sued for posting pictures of herself when JLO uploaded a street paparazzi photo of herself to social media wearing designer clothing and accessories. She might not have expected legal action. Photographer Edwin Blanco and Backgrid USA both filed nearly identical lawsuits against JLO, claiming that JLO didn't have permission to use his intellectual property for self-promotion, and he wants her to pay him $150,000 in damages. So, is this lawsuit valid? Was it illegal to repost this photo, or was it illegal to take it in the first place? According to the law, who owns the picture of JLO? The person in the image or the paparazzo who captured it? As a general principle, when you're lawfully present in a public space, you have a First Amendment right to photograph anything in plain view, as long as you're not violating other laws, such as, but not limited to, trespassing, stalking, harassment. So, this paparazzo was legally entitled to take a picture of JLO on the sidewalk, just like he'd be legally entitled to take a picture of you or mostly anybody else out in public. There's no reasonable expectation of privacy in public spaces, especially for celebrities. That's why it's called a public space. Furthermore, paparazzi photography is considered celebrity journalism, which is still protected as journalism, again under the First Amendment. This means that paparazzi have the right to take, publish, or sell pictures as an expression of our freedom of press, as long as they don't break any laws while doing it. Additionally, some states have anti-paparazzi laws that are more strict with the type of behavior that's allowed. So if the paparazzo was within his right to take the picture, it all comes down to copyright law. Copyright law in the United States broadly protects the intellectual property of the author of the creative work and/or the entity that owns the rights to the photograph. And when it comes to photographs, the author is the person who took the picture. So yes, the paparazzo who snapped the picture of JLO is the lawful owner of that photograph, even if JLO is the subject of the photo and didn't consent to it. By reposting a copyrighted work for self-promotion, she is infringing on the paparazzo's intellectual property according to the law. And he has a case to claim damages. Sorry, Jenny, but that's fair game on the block. As of June 28, 2025, both lawsuits were dismissed with prejudice, which usually means the case is over permanently. While no official statements were made, this typically signals a private settlement. For now, the legal message remains. Even celebrities can't post paparazzi photos of themselves without permission.